be careful. When you get into a pissing match with an officer, who's going to win, right? Not only that, when you hang with dogs, you get fleas. So be careful who you hang out with. No, this has to be, it's something where, I'm going to kill you now. It's not, hey man, I'm going to do this in a couple days. How on earth are you going to know that you're parking more than 18 inches? Parking while black now?
Judge Fleischer stepped in to save Mr. Watkins from a trumped-up evading arrest charge in Harris County, Texas, after cops overreacted to a simple walk-away. Texas Penal Code Section 38.04 states, a person commits an offense if he intentionally flees from a peace officer attempting lawfully to arrest or detain him. But Watkins was merely outside a vehicle during a stolen car check, not fleeing a lawful command. The officer claimed Watkins ignored orders to stop and walked 100 yards, only halting when another unit arrived. Yet Fleischer saw through the flimsy story. No proof tied Watkins to the vehicle or justified the detention. With a sharp, "Was he standing while black?" quip, he found no probable cause, freeing Watkins from a year in jail and a $4,000 fine. His quick wit crushed the evil cop's attempt to punish a man for exercising his right to walk away.
We need, what's his name? Watkins. Mr. Watkins, did you just get out of jail? Where did you think you were going today? To the beach?
No, sir. No, storage. They actually locked it from me, and we were transitioning from moving, so I didn't have access to any of my clothes.
Please don't come in clothes. It's very disrespectful. Okay? All right. In shorts, you're in shorts.
I literally had this on for the left.
Mr. Watkins, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and any interviews. If you cannot afford a lawyer will be appointed to represent you. Okay.
This officer was the check by unit in uniform for a stolen vehicle call and arrived first at the scene. Suspect approached the vehicle to verify the license plate while defendant Watkins was outside the vehicle. Witness officer confirmed the vehicle and told the defendant Watkins to turn around and put his hands behind his back. Witness officer stated that the defendant Watkins started to walk away from the vehicle, ignoring all his commands. Witness officer stated that he tried to grab the defendant Watkins by the arm and the suspect pulled away and kept walking. Witness officer stated he again told the defendant Watkins to stop walking away, but he refused to stop. Witness officer stated that the suspect walked an incident of approximately 100 yards and stopped because he saw the other unit arrive at the scene.
What?
Said that he began to walk away with his hand basically, and he was continuing to walk about 100 yards, but another officer arrived.
What was he doing wrong?
This was a stop for a stolen vehicle.
Right.
That he was outside. Apparently, looks like.
But was he inside the vehicle at any time? Watkins.
I'll check it out, Coach.
Was he?
The license plate, that was via the license plate. He was outside the vehicle. Nonetheless, he was in the vehicle to say he was outside the vehicle.
Was he standing while black?
This. Because the officer doesn't know how far away he's individual from the vehicle, life, person of interest. But
Forget it. I'll find no probable cause in your case. Be careful. When you get into a pissing match with an officer, who's going to win, right? Not only that, when you hang with dogs, you get fleas. So be careful who you hang out with. All right, just go ahead and take a seat for me. We'll be back with you here momentarily, sir.
Fleischer didn't just toss the case, he dropped wisdom to shield Watkins from future cop harassment, proving Justice Trump's petty power plays. Texas Code of Criminal Procedure, Section 9.02 says, a peace officer may arrest an offender without a warrant only if there is probable cause. But the officer's vague tale of grabbing Watkins's arm and chasing him 100 yards lacked any solid basis. The judge mocked the absurdity, why escalate a non-issue into a crime, and warned Watkins to avoid pissing matches with cops who always win those battles. By dismissing the charge, he saved Watkins from a corrupt system eager to lock him up for nothing. Fleischer's blend of humor and fairness, capped with "when you hang with dogs, you get fleas," turned a bad arrest into a lifeline for smarter choices.
Is it parking while black now?
In a stunning courtroom showdown on November 22, 2024, Judge Fleischer saved Mr. Hardy from a bogus marijuana possession charge sparked by a cop's obsession with a car parked 18 inches from the curb in Harris County, Texas. Texas Penal Code, Section 481.121 states, "A person commits an offense if the person knowingly or intentionally possesses a usable quantity of marijuana." But the officer's entire case rested on a shaky transportation code violation, not criminal intent. At 4:30 a.m., the cop claimed he smelled weed after a female passenger approached him, leading to a search that found 1.9 ounces of marijuana. But Fleischer wasn't having it, questioning how anyone could measure 18 inches in the dark. With a sharp parking while black jab, he found no probable cause, dismantling the evil cop's flimsy excuse to harass Hardy. This jaw-dropping ruling exposed the overreach and freed Hardy from facing 6 months in jail and a $2,000 fine.
You embarrassed to be with your mom?
I separate
Got it.
family and spectators.
Okay. Good morning, Mr. Hardy. Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. A PC search was conducted and the officer located 3.5 in the driver's side door and one blue package with "Oops All Berry" on the front containing green leafy substance on the rear driver's side floorboard, one red package with Fruity Pebbles on the front containing a green leafy substance in the back seat, and two clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed one burnt marijuana cigar behind the front passenger seat and one small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road. So he was out.
How on earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Is it parking while black now? Come on.
Yeah. Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana from
because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumably the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the issue of what we're talking about?
Yeah, because they come to him because he comes to them. right? They're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
And Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night was this?
Trying to see that, Your Honor, give me a second. Is it 4 in the morning?
And Your Honor, I
4 in the
found,
morning.
4:30 a.m.
And you can delineate at 4 in the morning that parking 18 inches from a curb.
and I found the regulation, the statute in the transportation code where it says you have to park within 18 inches.
At 4 in the morning, you can tell.
Your Honor, the officer was,
Yes, I don't think so. All right, I'm gonna find no probable cause.
yes, Judge.
Guys, be careful, right? You know, they're always out there. Just be careful, do something with your life. Knowledge is power. Get into school, get an education, do something with your life. Life is hard as it is. And it only gets more difficult the older you get, all right? Okay, guys, please.
And we'll be sure to call the officer on this case to
Whatever you need.
understand why he did, in fact, pull them over for this amount of space.
Judge Fleischer didn't just stop at shutting down the case, he turned it into a lesson to protect Hardy from future cop traps. Proving smarts beat corrupt power plays, the officer's tale of a minor parking issue escalating to a drug bust lacked any solid ground. Fans watched Fleischer grill the timeline. Why would a cop target a parked car at 4 a.m. unless it was profiling, and then pivot to life advice? Knowledge is power, get an education. By tossing the charge, he saved Hardy from a system itching to punish him for nothing, showing evil cops don't stand a chance against his logic. This moment cements Fleischer's legacy as a judge who delivers justice with wit and heart.
You know, this has to be, it's something where, you know, I'm going to kill you and it's now, you know?
In this gripping courtroom video from March 17, 2025, Judge Fleischer dismantles a weak case brought by overzealous police in Harris County, Texas, against 18-year-old Mr. Fernandez. Under Texas Penal Code, Section 22.07, a terroristic threat requires intent to place any person in fear of imminent serious bodily injury. Yet, the prosecution's evidence was shaky at best. Threats made to family members, not directly to the mother, and lacking immediacy. The incident stemmed from a March 5th family disturbance call where Fernandez allegedly showed his 14-year-old brother gun pictures and boasted about armed friends claiming intent to harm his mother. But Judge Fleischer, with his razor-sharp legal mind, saw through the holes. The threats were vague, made days earlier on March 3rd, and didn't meet the legal threshold for imminent danger. Corrupt cops had rushed to slap a misdemeanor charge and a hefty $10,000 bond. But Fleischer's scrutiny exposed their overreach, proving the arrest was more about flexing power than upholding justice.
Are you Mr. Fernandez?
Yes, sir.
Morning, Mr. Fernandez.
Morning.
Sir, you're charged with terroristic threat of a family or a household member. You are facing up to a year in jail and or a $4,000 fine. The reason you're out now is your bond is set at $10,000, which is unusually high for a misdemeanor. I don't know why, but she's asking for a bond reduction. I'd like to know what happened in the case and we'll go from there. Okay.
On March 5th, 2025, an officer was dispatched to a family disturbance type call at a residence in Harris County, Texas. Upon arrival, the officer made contact with the defendant, and the complainant, the defendant's mother, was trying to make him leave the house because she felt like her life was in danger due to his behaviors and threats he made to kill her with a gun. The complainant provided text message from the defendant's therapist. The defendant also told his brothers about the threats. The defendant showed his 14-year-old brother pictures of guns and stated all of his friends have guns. The brother felt in danger. The defendant admitted he made multiple threats in the past of killing his mother with a gun.
So,
Did I hear a specific threat?
Not directly to the mother, but he had threatened to kill the mom to other people in the family.
That's not, but a terroristic threat has to be aimed to a specific person, and there
Yes.
has to be immediacy.
And my response to that would be that it was aimed towards the mother, threats to kill with guns while showing pictures of guns that his friends have access to shows immediacy. And to show intent to put her in fear would be a question for the jury of whether he intended to make her feel fear, whether or not it was directly to her or to others.
Where the threat is.
So he told his brothers that he was going to kill his mother.
And
That is what the complainant stated. I don't have a time. Oh, wait. As per mother, the last time the defendant had made those threats was 2 days ago. So on March 3rd.
that's not even good.
no, this has to be, it's something where, I'm going to kill you, MF, now. It's not, hey man, I'm going to do this in a couple of days, when I get up to it, because I'm kind of lazy, I got shit I need to do. It don't work like that.
I understand. I'm just concerned, so.
Gotta be careful. You got but one life. How was jail? Sucks, right?
Yeah.
I mean, we're not asking for much. All the knuckleheads that have guns that run in the street, they're going to end up in here one day. That's all. I tell you, don't start asking anybody when you get back to the tank, Really, life is too short to live in a box like this. You don't need a gun. How old are you?
Just turned 18 on March 5th.
You don't need a gun. Get your ass back into school, man. Knowledge is power. You want to make some money? Learn something. She's amazing. Look at her. How much money you make? Don't answer that. She makes a crap load of money because she knows things.
Yeah.
That's what life's about. Fancy vacation, nice cars, these big ass beaches, blue water. That's what life's about. But you get it in school by gaining knowledge, not with a gun, right?
Mm-hmm.
But if I know probable cause, do something, man.
Sure.
Get back into school, learn something.
He's in school, so he needs to finish school.
Yeah.
Okay,
he's gonna do.
you're gonna get out today. Be somebody.
Yes, sir.
You're not a statistic. All right.
Thank you, Your Honor.
What was the case again? That was Fernandez.
His ruling of no probable cause didn't just free Fernandez. It humiliated the sloppy police work that tried to railroad a teenager on flimsy grounds. Beyond tearing apart the cop's case, Judge Fleischer turned the hearing into a masterclass on redirecting a young life, showing corrupt law enforcement how real justice works. Texas law demands probable cause under Section 9.02 of the Code of Criminal Procedure, stating, "A peace officer may arrest an offender without a warrant only if there is probable cause." But the police here leaned on hearsay and fear-mongering instead of facts. Rather than let Fernandez rot in custody or become another victim of a system eager to lock up youth, the judge seized the moment to mentor him. "Knowledge is power," he declared. This showcased a judge who outsmarts and outclasses the system's worst actors, proving justice can heal as much as it can punish.
Okay, we don't know when. The officer can't do any more questions than that.
In a tense Harris County, Texas courtroom on March 26, 2025, Judge Fleischer rescued Mr. McCasey from a flimsy driving while intoxicated charge after a major crash left cops grasping at straws. Texas Penal Code Section 49.04 states, "A person commits an offense if the person is intoxicated while operating a motor vehicle in a public place." But the officer's evidence was razor thin, just an odor of alcohol, keys in McCasey's lap, and an admission to drinking before driving. The cop leaned hard on the crash and field sobriety tests, 4 out of 6 HGN, 4 out of 8 walk and turn, 3 out of 4 one-leg stand. But Fleischer wasn't convinced, pointing out no slurred speech, bloodshot eyes, or details on when or how much McCasey drank.
Good morning, Your Honor.
Hey,
How's it going?
it's been a while. How are you? What's
Doing all
new?
Yes.
Yes.
I'm right. Thanks. Good morning, Mr. McGaskey. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Mr. McGaskey, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please don't say it.
October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk-in turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of an alcoholic beverage.
Just an odor. Anything else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's nothing, no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor was observed, and then the statement made about him drinking.
McGaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking, he's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many, Judge.
I understand this. I understand, Michael, but I need just a little bit more than just an odor in an accident.
And admissions of drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
All right, I'm going to find no probable cause, Mr. McGaskey. It's very possible if they take it to a grand jury and indict it, but so I would be on the lookout, number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm going to find no probable cause. Just take a seat from me. Thank you, Mr.
With a sharp, I need just a little bit more than an odor and an accident, he found no probable cause, saving McCasey from 6 months in jail and a $2,000 fine. This brilliant ruling exposed the evil cops' rush to pin a DWI on shaky ground, proving Fleischer's smarts reigned supreme. Judge Fleischer didn't just toss the case, he used it to shield McCasey from a corrupt system while dropping a reality check on the dangers of drinking and driving. The officer's report lacked the meaty details, like timing or quantity of alcohol, needed to justify the arrest. When the prosecution argued the crash itself proved intoxication, Fleischer shot back, "We don't know when, we don't know how many," dismantling their lazy case with precision. By finding no probable cause, he spared McCasey from evil cops itching to lock him up, though he warned a grand jury might still bite. But he'd saved a man from injustice while urging him to stay sharp on the road.
Like if there was some kind of description, someone in the car had assaulted someone or something to that nature, you know, but just...
officers were able to confirm the vehicle by the license plate.
In a Harris County, Texas courtroom on June 29, 2024, Judge Fleischer shut down a shaky evading arrest charge against Mr. Ogaro, saving him from cops who chased him for no solid reason. Texas Penal Code, Section 38.04 states, a person commits an offense if he unintentionally flees from a peace officer attempting lawfully to arrest or detain him. But the officer's vague, assault in progress call tied to a black SUV didn't link Ogaro to any crime. They confirmed his vehicle by license plate, yet when he walked away, ignoring commands, they launched a quarter-mile foot pursuit. Fleischer wasn't impressed, asking, Cars don't assault people. Where's the evidence? With no clear victim, assailant, or specifics beyond a generic call, he dismantled the evil cops' overzealous hunt, proving they can't just chase and cuff without facts. His sharp skepticism set the stage to spare Ogoro a year in jail and a $4,000 fine from a flimsy case.
17, Ogaro.
Ogaro. Ogarro. For sure. Good morning, Mr. Ogaro. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer, will lawyer be appointed to represent you, sir?
On June 29th, 2024, officers were dispatched to an assault in progress in Harris County, Texas. Officers observed a black SUV which had 3 people inside and confirmed it to be the vehicle of interest. The defendant got out of the driver's side of the vehicle and began to walk away from the officers. The officer then told everyone to stop, and the defendant kept walking away, ignoring commands. The officer told the defendant multiple times to stop, but the defendant did not comply and began evading on foot from the officer towards an apartment complex. Foot pursuit began, and another officer then drove towards the defendant and gave verbal commands to stop, announcing Houston police stop. The defendant was eventually caught, and officers were able to place the defendant in handcuffs. The total approximate length was 1/4 mile. Upon return to the original scene, all other parties had left the scene along with the vehicle of interest.
What was the detention for? What was he doing wrong?
Officers were there on an assault call and had a description of the vehicle. And once they saw it, they approached, and that's whenever defendant.
Do you have more than just an assault call? Any kind of identifying factors? I mean, it's really just vague how there's just cars don't assault, you know? Like if there was some kind of description, someone in the car had assaulted someone or something to that nature, you know, but just.
I mean, officers were able to confirm the vehicle by the license plate given from the call.
Okay.
So they confirmed that it was the defendant's vehicle that they approached on.
Do they say that someone assaulted someone, that there were?
Just that it was just an assault call, Your Honor.
Yeah, I need more than that. I mean, it's really vague. It's presumptuous. It's, no. Beetle, do you have anything else?
I'll look at it. Just let me take a look at it.
Okay.
If you just
do me a solid, will you? Just take a seat for me. I want to make sure that there's probable cause if there is. If not, I'm going to cut you loose, but I want to make sure that there really is. So just give me a second and then we'll get back with you.
Later that day.
Judge, I see what you're saying. If you want to do whatever you want to do.
That's it?
And then I'll resolve it. I think you were questioning whether it was probable cause related to the case.
There's nothing new?
I don't really disagree with you.
Okay. Come up, sir. So this was Ogaro. Okay. Mr. Ogaro, I'm going to find that there's no probable cause in your case. Just be careful out there, man. People are always out to hunt you down. You know what I mean? Just be careful. Don't put yourself in the spot. Okay? All right. You're free to go. For sure.
Judge Fleischer didn't just question the prosecution's flimsy case, he ruled there was no probable cause, turning a wrongful arrest into a triumph over corrupt policing. Texas Code of Criminal Procedure, Section 9.02 says, a peace officer may arrest an offender without a warrant only if there is probable cause. But all the cops had was a vehicle match and Ogaro walking toward an apartment complex. No assault details, no witnesses, nothing concrete. It's really vague, it's presumptuous, he snapped, refusing to let evil cops railroad a man based on hunches instead of proof. After a brief pause to confirm, he found no probable cause and freed Ogaro, warning him, "People are always out to hunt you down. Be careful." This masterstroke saved Ogaro from a system itching to lock him up for being in the wrong place, cementing Fleischer's legacy as a shield against police overreach. Like and subscribe for more police cam stories. Watch the next recommended video click to watch now.